morning, everyone. Thank you. As Brenda Stoddard mentioned, my name is Martha Nguyen. Together with my friend and colleague Tina Kiang, we are in charge of developing and publishing all of the policy documents to help implement GDUFA 3. I'm going to start by very briefly describing the types of policy documents that we use. The first one is a guidance for industry. This is a document that is intended to describe FDA's current thinking on a particular subject. It contains non-binding recommendations. So if you would like to propose a different way of complying with the existing statutes and regulations for ANDA approval, you can do so by contacting us or submitting a justification in your application. We also publish manuals of policies and procedures. These are internal documents that are intended to provide additional clarity for FDA staff in implementing these policies and procedures related to, in this case, GDUFA. We make them external so that external industry and regulated industry can have a better understanding of the policies and procedures that we use to implement GDUFA. They are all published on our website. The guidances themselves will be announced in the Federal Register with a Federal Register notice called a Notice of Availability. We have a number of different ways that we identify the need for GDUFA policy development. The very first and the most important is the GDUFA commitment letter itself. In particular, the Section 9 of the GDUFA commitment letter specifies specific documents that we committed to during negotiations to publish to implement GDUFA. There are many other sections of the GDUFA commitment letter that don't have a specific commitment to publish a document, but we will identify a need for additional clarity to be able to explain better how we're going to implement that particular program provision of GDUFA. In those cases, we will on our own publish either a guidance or a map or sometimes companion documents that both assist industry and FDA in being able to implement those provisions. The other area of GDUFA policy development is existing GDUFA 2 documents that we had published in the last iteration. In that case, we would be updating the existing document to reflect any changes that we had made during the GDUFA 3 negotiation. There are, under GDUFA 3, a number of program enhancements that we agreed to where there is not specific clarity in the GDUFA commitment letter itself. We will choose to publish a guidance or a map to provide greater clarity around our thinking and how we intend to implement GDUFA in those instances. And then finally, we heard both from you and from internal stakeholders some of the areas where we could do things a little bit differently during GDUFA 3. Those lessons learned do inform our policy development process as well. So now I'm going to introduce a challenge question. And it is, can you or can you not make comments to a guidance at any time? Does anyone have a? I see some nodding and some shaking. I will tell you that the answer is true. You can comment on any guidance at any time, even if the guidance comment period is closed. We try to do either a 60 or a 90-day comment period for guidances, which allows us to close out that part of the policy development process so that we can consider all of those comments when we start finalizing a guidance. But even if the guidance is final, or even if the docket has closed, you can still comment on that guidance. You'll go to regulations.gov, and the comment now button may not be live, but you can click on the document and submit another comment. I have in my office, and I'm sure that Tina does as well, a lead regulatory counsel and a lead project manager that monitors each docket and considers those comments, disseminates them to the right subject matter experts internally so that we can very carefully consider your feedback. Next, I will go through the policy documents that we have published to date to implement GDUFA 3. I organized these documents in order of the different chapters of the commitment letter, the first being the one related to performance goals. These are then subsequently published in or ordered here in order of date of publication. The very first document that we published related to performance goals was a GDUFA 3 commitment to open a docket to solicit comment on Appendix A of our 2018 amendments guidance. Some of you may know that Appendix A included a list of what we consider to be major deficiencies. If major deficiencies were present, a longer goal date would be assigned to the review of the amended application once submitted. So this docket was intended to solicit additional feedback from regulated industry on the deficiencies where the additional clarity was needed, and perhaps where there might not be as much agreement on the nature of the deficiency or the severity of it. We also updated our existing GDUFA 2 guidance on prior approval supplements under GDUFA. This was a GDUFA 2 guidance, and we made very minor changes to be able to update it for GDUFA 3. We published that, I think, within days of GDUFA 3 starting in October 2022. We also, later that year, published a guidance on failure to respond after a CR letter is issued under GDUFA. This guidance is intended to assist applicants in responding to CR letters and to reflect our thinking on what happens after a CR letter is submitted and the types of courses of action that an applicant may have upon receiving a CR letter. The next set of documents that I'll go through are the ones related to program enhancements under GDUFA 3. The first one here was also published at the same time as the PAS guidance I mentioned on the previous slide. And this one is to update an existing GDUFA 2 guidance document on post-complete response letter teleconferences between FDA and applicants. And it is, this type of teleconference is to clarify the deficiencies that were identified in the CR letter. This guidance included very minor revisions for GDUFA 3. We also, at the same time, issued a guidance on information requests and discipline review letters. These, which we call IRs and DRLs, are part of the communication that FDA engages in with an applicant during the review of an ANDA. This guidance was updated to include additional information reflecting the GDUFA 3 commitment letter. I noted earlier that we often will publish a manual of policy and procedure to provide additional details to staff. In this case, we had a guidance and a companion map that both had an outward-facing component, the guidance on IRs and DRLs, and an inward-facing component, the map on the same topic, to provide additional policies and procedures for staff in reviewing and issuing IRs and DRLs. Next, we also updated a map that we informally call the Communications with Industry map. This map has general principles and procedures for communicating the review status of applications with the applicant, consistent with what we committed to under GDUFA 3. And then finally, we published a map on suitability petitions, which describes how FDA will respond to suitability petitions that were submitted by or on behalf of applicants. And this reflects our GDUFA 3 commitments around suitability petitions, which was new to the GDUFA program under GDUFA 3. In June 2023, we published the guidance on cover letter attachments. This one is intended to provide for applicants optional attachments that can be used when preparing cover letters to accompany a controlled correspondence or other ANDA submissions, such as original ANDAs and amendments and supplements. These do not replace the recommendations for what should be contained in a cover letter, but are intended to provide additional recommendations when preparing those documents. We more recently published the amendments and requests for final approval to tentatively approved ANDAs. This guidance is intended to provide our recommendations and current thinking on the timing and the content of amendments to tentatively approved ANDAs. The goal here is to be able to facilitate not only timely submission of those requests, but enough information that allows us to be able to take a final approval action on the earliest lawful ANDA approval date. This guidance replaced an existing guidance that we had published previously in 2020. We at the same time also published a guidance that is a revision to an existing guidance on requests for reconsideration at the division level under GDUFA. This one describes the types of the types of actions related to an ANDA that can be where we can submit a request for a reconsideration, and these go through the division level and would be appealed up through the the formal dispute resolution process. The guidance revision was intended to capture the additional commitments and changes that we agreed to under GDUFA 3. This guidance, the next guidance is the post-warning letter meetings guidance, and I'm going to defer additional description of this guidance to my colleague, Tina. The next set of policy documents are related to implementation of the pre-ANDA program. The first one in this area is around competitive generic therapies. This guidance includes a description of the process that applicants should use when requesting a designation of a CGT and the criteria for the CGT designation. It includes some information around the types of actions that FDA would take to expedite a drug application that is designated as a CGT. And the changes that we made to this existing guidance were to include GDUFA 3 program updates. We made similar revisions in the same time frame at the beginning of GDUFA 3 to the formal meetings guidance. This describes the types of meetings that applicants can request when preparing an ANDA for a complex product. It includes specifically information on requesting as well as conducting these types of meetings, both the pre-submission meetings as well as the mid-cycle review meetings and the post-complete response letter meetings. This was an existing GDUFA 2 guidance that we updated to incorporate GDUFA 3 changes. We had here a companion map called Evaluating Requests for and Conducting Product Development and Pre-Submission Pre-ANDA meetings. These are two of the types of meetings that developers of complex products can avail themselves of. This map contains additional information for staff in accepting and granting those types of requests. It was made public as a map to increase transparency so that applicants can have a better understanding of what we are looking for when considering these requests. We also published, a revision to the controlled correspondence guidance. This is the guidance that describes the process by which generic drug applicants and their representatives can submit to FDA questions before the submission of an ANDA through what we call a controlled correspondence. The guidance also describes the process for our responding to and providing communications about those controls. We published a guidance on PSG meetings between FDA and ANDA applicants. This was a new meeting type, and this guidance was intended to provide additional information on those types of requests for those meetings, what should be included in the meeting package, as well as how FDA would consider those requests and the timing around the scheduling and conducting of those meetings. And we also published a more recent version of the controlled correspondence guidance in March of this year. Next, I have a challenge question. which is what type of policy document is an internal document and which one is an external document. Is a guidance an internal document? The answer is that the map is internal to FDA. It is made public to increase transparency. The guidance is intended to be directed at external industry. FDA staff also refer to that as a very important resource. And next, I will turn it over to my friend and colleague, Tina Kiang.
So there are also a number of policy documents that were developed in OPQ, and some of them were mentioned by Susan earlier today. And so the first one that I will be talking about is the guidance regarding the review of drug master files in advance of certain ANDAs submissions under GDUFA. This describes when an early assessment of type 2 DMFs, also referred to as the DMF prior assessment, can be reviewed and requested and commenced by the DMF holder. It provides recommendations to the DMF holder regarding when the request can be made. The request can be made 6 months prior to the planned submission of certain ANDAs or prior approval supplements. The guidance lists the eligibility and the submission requirements for such requests. We have a number of policy documents with regard to facilities. The first one is called Facility Readiness Goal Date Decisions under GDUFA. It incorporates, under the GDUFA commitment letter, it was requested that we incorporate how FDA would assess a goal date to a facility if the facility is not considered ready for inspection. If a facility is considered not ready for inspection, meaning that it was checked off as not ready for inspection under Form 356H, then a goal date of 15 months would be assigned to that impending ANDA. This would allow FDA to focus resources on substantively complete applications with facilities that were ready for inspection. It also outlines, for example, if after those, after the 15 months, if the facility is still not ready for inspection, what the new timelines would be. The next guidance is regarding the pre-submission of facility information related to prioritized generic drug applications. This was published in December 2022. This is actually a revision of a November 2017 guidance on the same topic. Under the commitment letter, under the GDUFA 3 negotiations and commitment letter, it was requested to kind of streamline the information that was previously published in that 2017 guidance. And so in this guidance, it discusses the content, timing, and assessment of what the pre-submission facility information, pre-submission correspondence, or PFC, for a priority ANDA, such that the ANDA would be eligible for priority review. We greatly streamlined the type of information and the amount of information that would be necessary to submit for these pre-submission correspondences, such that it would reduce the burden essentially on sponsors submitting ANDAs, in particular, such that a PFC does not look like an ANDA light essentially on the CMC information. The next one, again, as previously mentioned by Susan in her presentation, is a map on the assessment of facility-based major to minor classification requests. And so this was published in June 2023, and there was also a minor revision in December 2023. This is, again, an internal policy and procedure regarding the assessment requests for facility-based complete response letter amendments for original ANDAs and prior approval supplements. In the GDUFA 3 commitment letter, it states that we discuss how OPQ and OGD should coordinate these responses and receive and accept these amendments. So when these reclassification requests are received, this map outlines how these amendments will be coordinated within the agency by OGD and OPQ in order to grant or deny the request. And finally, and I realize that this is specifically a facility one and not for the complete response letter, and I apologize, but this is for post-warning letter meetings under GDUFA, and it talks about information on the implementation of post-warning letter meetings for certain facilities. So it talks about how an eligible facility may request a warning letter meeting after receiving a warning letter. Within it also makes recommendations regarding the information that would need to be submitted, and the meeting request would be regarding the ongoing remediation efforts by the facility in response to CGMP deficiencies in the referred warning letter. How to prepare the meeting package, including what should be included in the meeting package and the specific questions and responses that the facility intends to provide, and how FDA will conduct those meetings. Finally, we have a guidance document regarding user fees. In the GDUFA 3 commitment letter, the user fee structure was changed somewhat. And so this is actually a revision of a previous guidance, which reflects the changes that occurred in the GDUFA 3 commitment. It explains the new fee structures, the types of fees, and which entities are responsible for paying those fees under the commitments. While a fee guidance is pretty standard and boring, there is one notable addition to the guidance in response to fulfilling one of our commitments, and that's regarding API excipient mixtures. In this guidance, it notes that manufacturers of API excipient mixtures are generally required to pay the finished dosage form facility fee. However, there is an exception that's outlined in this guidance, and it's for fee purposes only. So if, when the mixture, specifically this API excipient mixture is produced, because the API is unstable, meaning that it cannot be transported on its own, then a sponsor may request, the API manufacturer may request that the fee be waived. This, when we're talking about unstable and cannot be transported on its own, what we mean is that mixing the API with an excipient would prevent the loss of one or more critical quality attributes. For example, adding an antioxidant to increase chemical stability of such an API. If a company is claiming that they can take this exception and therefore not pay a fee, they would have to provide a rationale that is clearly stated and the data that is supportive of that request. And so that's all I have, but I do have, I am going to talk a little bit about upcoming documents. And so, as Martha said, in the GDUFA commitment letter, we do note a number of guidance documents and other documents that we have stated that we are going to publish. But also we are constantly looking at the commitment letter to see, where else in the commitments can we enhance? What documents can we revise such that, we continue to meet the commitments? And so there are still forthcoming revisions to previously published documents to update in order to meet the commitments. These typically are, what we call level 2 revisions, meaning they're minor revisions because the general overall policies haven't changed, but there are minor tweaks as a result of the commitments, for example. And because of that, just so level 2 guidances, when they are published, they don't publish with a notice of availability. And so these things aren't officially announced, but keep a watch on them. Make sure that you are looking out for them. And I believe OGD publishes at the end of the year a document that or I believe ORP publishes at the end of the year, or the beginning of the year, the documents that are on the way. So again, we are continuing to do our work to fulfill the GDUFA commitments, and this is just a sampling of what we've already accomplished. We are also committed, and a lot of the guidances that we have shown are draft guidances, and we're extremely committed to making sure that these draft guidances become final. And the reason why is because we want to provide assurance to the industry as well as, to our FDA colleagues as to what our current thinking is when we're doing our work. Draft guidances are not for implementation. And so, while they are out there and they generally reflect, they aren't officially implementable. And so finalizing those guidances provides assurance to both FDA and the industry as to what our recommendations are and the consistency with which we apply those recommendations. And finally, at the beginning of every year and in July, CDER publishes what's called the guidance agenda. And this is not just on GDUFA 3, it's not just on quality, it's about any topic related to the work that's being done in CDER. And so in using that guidance agenda, you can see what is forthcoming and what is projected to be published in the coming year. Now, that is also to say that's not exclusively what's going to be published in the coming year. It is just the minimum of what our goals are. There are guidances that are not on that list that will be published, sometimes because there are priorities that come up or that, we unexpectedly finish faster, which does happen sometimes. But also to note that what's on that guidance agenda typically is upcoming draft guidances. The only exception is that on that guidance agenda, we will publish what we call immediately in effect guidances as well, which means that it will be the first public notification that, that a guidance on that topic will be published. But typically what's on that guidance agenda is going to be the upcoming draft guidances for the coming year. So, we've done a lot of work collectively, between OGD and OPQ, and I value the collaboration that we have between our two offices in getting a lot of this work done. We have done an amazing amount of work in the last 2.5 years, coming out of the GDUFA 3 negotiations and commitments, and are looking forward for the next couple of years to continue doing our work to meet the commitments that we have in the GDUFA 3 and moving into GDUFA 4. And so I come to our last challenge question, which is, and it's an easy one because I just talked about it, where can you find out what guidance documents CDER is currently working on? And so, again, this is the CDER guidance agenda, which was currently updated in 2024. There will be a mid-year update in July of 2024. Hopefully, when you get these slides, you will be able to click the hyperlink, because this hyperlink here will take you directly to that PDF file.